Call the meeting to order. And the first item on the agenda is bill introductions. Senator Hildebrand.
Thank you, Mr. Chairman. I'd like to introduce RS 1664. This is authorizing counties to distribute vaccines ahead of state recommended timelines. This is in response to the current administration threatening to withhold vaccinations to counties that are doing a good job of vaccinating their constituents, and try to stop that from being used as a tool for enforcement.
Thank you. Is there any objection, any questions? Any objection to introducing this bill? Seeing none, bill will be introduced. Thank you. I have a bill introduction, and it is 21 RS 1433, and it is on introducing the Article 5 Convention of States. Is there any questions to introducing that bill? Yes, Senator Faust, go.
Thank you, Mr. Chair. So will we be meeting tomorrow?
Yes.
Okay, thank you.
We will, the plan is, we've got a full agenda. The plan would be to work tomorrow, and today's Thursday though. No, today's Wednesday. Well, I'm lost. We will be working Friday. We do have some work to do on Friday also.
Okay, I just wanted to know because I'll have to bill.
Okay.
Thank you.
Okay. Okay. Is there any other comments on introducing RS 1433? Seeing none, the bill will be introduced. Okay. Is there any other bill introductions? Seeing none, we'll move on to a hearing. Our first hearing. Our first hearing is on Senate Bill 255, which is allowing the Director of Alcoholic Beverage Control to suspend or revoke driver's license under the Kansas Liquor Control Act or the Club and Drinking Establishment Act. And we do have a staff briefing. Jason, are you here?
Yes, Mr. Chairman, members of the committee. Senate Bill 255 amends two statutes, one in the Kansas Liquor Control Act and one in the Club and Drinking Establishment Act. Both amendments would simply add language to those statutes so that the director could suspend, cancel, or revoke a license for a violation of a lawful order issued by the director. That language is not currently in those statutes. And so with this amendment, not only a violation of the respective acts, but of any lawful order issued by the director could result in license disciplinary action by the director. The bill will go into effect on July 1st of this year if enacted, and I'd be happy to answer any questions.
Thank you. Do we have any questions? Yes, Senator Faust Godot.
Thank you, Mr. Chairman. Jason, so would this happen like after like the third time or the first time? Do they get a little to address the issue, and then is this like after, if they don't do that, then the revoking of the license?
I will defer to the director in terms of the timeline that her office uses for disciplinary actions. But if her office, if she has issued an order pursuant to her authority under either of these acts, and those orders are not complied with, then potentially the licensee could be subject to suspension, revocation, or cancellation of their license.
Any other questions? Not. Thank you, Jason. We'll go to the proponents, and we have Director Beavers with the ABC, and I did see her online just a moment ago. Director Beavers.
Mr. Chairman. My name is Debbie Beavers. I'm the ABC Director. Thank you for the opportunity to testify. We are a proponent of this bill. Some of you may recall this is the same bill as last year's Senate Bill 432 that was passed out of the committee and placed on the consent calendar. It was then taken off and amended on the Senate floor, and it later died in the House committee due to the pandemic. ABC proposed this bill in an effort to clarify and streamline disciplinary procedures when a licensee has committed a liquor violation. Simply put, this bill just adds the ability to penalize a licensee for their failure to comply with a lawfully issued disciplinary order. I do want to point out the bill does not add a new violation. It just provides clarity and allows for a more streamlined process under the Kansas Administrative Procedure Act. Currently, there is no statutory provision giving the ABC any recourse in the event that a licensee fails to pay a fine when it has been imposed by a disciplinary order pursuant to the Kansas Administrative Procedure Act. All the ABC can do is refuse to renew the license if the fine is still due. Since the licenses are valid for 2 years, it could take almost 2 years to be able to collect the fine. So under statute, the director is authorized to suspend or revoke a license for any violation of law, and it can also impose civil fines for violations. Failure to comply with the order doesn't mean that the license will be suspended or revoked for failing to pay the fine. They would likely be fined as another separate violation. Our current process is rather convoluted. A summary proceeding order is issued. It states that the license is immediately suspended and a fine is assessed. Then the order goes on to state that the suspension is stayed for 30 days. If the licensee doesn't pay the fine within 30 days or request a hearing, then the suspension stay is lifted. The license is suspended, but the licensee may be unaware that if they did not respond to the order, and they continue operating until the ABC finds them operating or a fine is due at renewal. This is really confusing for the licensees, and it is difficult to track administratively. So if the bill is passed, the new process would be that the summary proceeding order is issued with a fine assessed. The licensee has 30 days to pay the fine or request a hearing. If the licensee fails to pay the fine, another summary proceeding order would be issued, which lists the initial violation, fine assessed, and then in the new violation of failing to comply with the order of the director. If the licensee then fails to pay the fine or request a hearing, the license can then be fined, suspended, or even revoked. After doing some research, the ABC discovered that nearly every other regulatory agency or licensing body has some type of provision for failing to comply with the provision of an order. This change proposed will make it easier for licensees to understand the orders and follow the administrative orders, and it will also streamline our overall process for our staff as well. Thank you, Mr. Chairman. I'll be happy to answer any questions.
Director, is there any questions? Yes. Senator Cools.
Thank you, Mr. Chairman. Just curious, who's currently involved in the hearing? You talked about the hearing process.
The hearings are held before the director of ABC, which would be myself. And they're held currently with COVID. We're doing them virtually, but they do request a hearing. And once they request a hearing, they can work with our Assistant Attorney General and come to a settlement prior to a hearing as well. They have that option.
Any other questions? Yes.
I guess I meant in particular, who's involved in the hearing? What individuals?
Okay, the licensee and the representative, they can have an attorney represent them. They can both be present, and anyone else the licensee wishes. Myself as the director or the hearing officer, and then our Assistant Attorney General and legal assistant are all involved in the process.
Any other questions? Seeing none, thank you very much. We also have Amy Campbell has permitted with the Kansas Association of Beverage has turned in written testimony, and you should have that in your packet. Are there any neutral or opposition? Seeing none, thank you very much. We'll close the hearing on 255. We'll open the hearing on Senate Bill 258. And this is clarifying the license terms and electronic submission of tax payments, reports, and documents for holders of a special order shipping license. And with that, we'll have a staff briefing from Jason.
Thank you, Mr. Chairman, members of the committee. Senate Bill 258 amends one statute in the Liquor Control Act, 41-350. This statute governs special order shipping licenses. This specific type of license is issued to wineries that want to ship wine into Kansas directly to the consumer. Under current law, licensees are required to collect the required gallonage tax on the wine shipped into the state and remit those taxes to the Secretary of Revenue on an annual basis. Senate Bill 258 would require the licensees to remit the gallonage taxes on a quarterly basis and to do so electronically. Those gallonage taxes are established in statute in 41-501. The bill would go into effect on July 1st of this year if enacted, and I'd be happy to answer any questions.
Are there any questions for Jason? Seeing none, thank you very much, Jason. First proponent is Director Debbie Beavers again. Director?
Good morning, Mr. Chairman, committee members. Again, my name is Debbie Beavers, ABC Director. Thank you for allowing us to testify as a proponent. This bill is the same as Senate Bill 432 that last session passed a similar fate to the previous bill that we heard dying in the House committee. In the 2019 session, license effective dates were changed from the date the license was issued to the date specified on the license to assist us with being friendly. Special order shipping licenses were in a different statute and we overlooked those. So there's a technical change for that so that the licenses will be uniform on the effective dates. And the most important thing that this bill does is help us address the unlawful shipments of alcoholic liquor that are a known problem. This would change the annual paper report and payment requirement to a quarterly report and payment, which must be done electronically. Currently, ABC receives extremely heavy mail in January, as their current reports are required to be filed by January 15th, file that annual report and pay the gallonage tax. With the electronic reports, it will reduce the burden of this mail. And believe me, I know I helped process that mail this year with all of our staff working remotely. But more importantly, it will allow us to match those monthly common carrier reports to these special order shipping reports in a timely fashion, since they'll be filed quarterly. And with it being done electronically, it will make it much easier for us to identify those unlawful shipments of alcoholic beverages to Kansas residents. Those unlawful shipments do result in unpaid gallonage tax and liquor enforcement taxes. And Mr. Chairman, I'll be happy to stand for any questions at the appropriate time. Thank you.
Thank you very much. Are there any questions for Director? Seeing none, thank you very much. The next proponent is Larry Ann Brown of the Wine Institute. Good morning.
Good morning. Bring that down to my level here. Is it on?
Yeah.
I think so. Morning, Mr. Chair and members of the committee. I'm Larry Ann Brown. I'm here today to represent the Wine Institute. As many of you know, the Wine Institute is made up of about 1,000 wineries out of California and some of the businesses that are associated with those wineries. As mentioned last year, many of our member wineries rely on the direct-to-consumer shipment of wine to promote their wine and to establish brand loyalty. And we thank the legislature for this ability. In order to ensure the Department of Revenue receives the taxes that are due to the state of Kansas, we do support the change that is presented to you in 258, which will allow the wineries to remit taxes on the quarterly basis by our members and the other wineries that ship directly to consumers. I'd also like to thank Director Beavers for working with the Wine Institute representatives to discuss the possible changes in remitting those tax timelines and for allowing wineries to remit those taxes electronically. I think it will help all of the parties involved in that. And with that, I'd be happy to stand for questions.
Are there any questions For Larian? Seeing none, thank you very much for coming this morning. Are there any neutral testimony? Any opponent testimony? Seeing none, we'll close the hearing on Senate Bill 258 and open the hearing on House Bill 2137. And with that, we'll have a staff briefing.
Thank you, Mr. Chairman, members of the committee. House Bill 2137 should look very familiar. It is in large part the same as Senate Bill 254 that this committee heard back before turnaround. The bill expands the categories of alcoholic liquor licensees who can sell cereal malt beverage. So this bill consists largely of amendments to the temporary permit statutes and the club and drinking establishment statutes to authorize permit holders and licensees to sell cereal malt beverage along with the usual alcoholic liquor that they are authorized to sell. There's also a change to allow alcoholic retailers to sell cereal malt beverage and deliver cereal malt beverage to correspond with that policy change. Main thing I wanted to note this morning, direct your attention to, the bill is different from 254 in that the House Committee of the Whole amended the bill during floor debate on pages 22 and 23 of the bill to amend, excuse me, KSA 41-2653. This is a statute that currently allows patrons to remove unconsumed alcoholic liquor from the licensed premises in a sealed, tamper-proof bag for consumption later at home. The amendments added to the House would also allow, take off the March 31st sunset date on to-go cocktail provisions. That's what it's generally known as. It's the provision that allows these clubs and bars and restaurants to sell alcoholic liquor for curbside pickup by patrons. That had been set to expire on March 31st of this year in Senate Bill 14 that was passed earlier this session. So the House first struck that sunset. Then it also authorized clubs and bars and restaurants to sell alcoholic liquor that is in the original unopened container. So under current law provisions, they would have to actually open the bottle of wine, open the bottles of beer, and then reseal them in order to sell them to the patron. Under the House's version of 2137, they would not have to do so. They can simply sell those sealed, unopened containers of alcoholic liquor directly to the patrons. There were some added provisions to that. The House did limit such sales to can only be done up to 11 p.m., which is the standard cutoff for retail liquor stores. They also made amendments regarding the size of such unopened original containers so they can sell beer, cereal malt beverage, and wine. And mixed drinks without being subject to the individual drink size requirements under the Club and Drinking Establishment Act. But you could not sell hard alcohol, spirits, so to speak, in bulk in an original unopened container. Those would still be subject to the individual drink requirements of the Act. Again, the bill goes into effect on July 1st if enacted, and I'd be happy to answer any questions.
Are there any questions? Yeah, Senator Falscato.
Thank you, Mr. Chairman. Jason, so say that again. So they could purchase and then open it up and then seal it and then serve it or sell it?
So under the House's amendments, you could go to a restaurant and purchase a bottle of wine, drink half the bottle of wine, and then the restaurant could seal it up, put it in a bag, and let you take the rest of the bottle home that you would purchase there at the restaurant. Under the House amendments, you could order a meal to be picked up curbside and order a bottle of wine to go with it. And the restaurant would be able to let you take away both your food and the unopened bottle of wine from the restaurant when you pick up your order. is what the House amendments essentially did.
Jason, so we could already do that. That was already in law, whereas you are at a restaurant and could seal up your half-drinking bottle of wine and take it with you. But what are you're saying that the curbside, the bottle of wine would be sealed and sold, or sold and not sealed?
So currently, if you open the bottle on the restaurant premises, you can take the remaining bottle home with you. Under current law, up until March 31st, you can also call in an order, have them say, order a beer to go with your burger, and the restaurant could open the beer and put it in a separate container that's sealed for transport and let you carry away your beer and your burger as well. That expires March 31st, except under the House bill, they're doing away with the sunset that would make that allowance permanent. The other addition the House made would be to allow you to order your burger and your beer, and they could just let you take the bottle, the unopened bottle of beer, home with you along with your burger, because it's already sealed in the original container.
Any other questions? Seeing none, thank you, Jason. The first proponent is Jason Watkins on behalf of Kansas Beer and Wholesalers Association. Do we have anybody? I don't see Jason here. Is anyone speaking for him? If not, we'll move on to Amy Campbell with the Executive Director of Kansas Association of Beverage Retailers. Amy, welcome.
My name is Amy Campbell. I work for the Kansas Association of Beverage Retailers. The underlying bill is the same bill that you all had hearing on, Senate Bill 254. So the front page of my testimony talks about that bill and why my association and the Association of Beer Wholesalers had requested that bill. In the interest of time, I'm going to kind of move ahead and talk about the amendments. Prior to the enactment of the Emergency Management Act last spring, drinking establishments could not sell takeout alcohol except for that doggy bag provision that we spoke about here with the wine already being opened. So in the emergency, restaurants desperately needed a way to continue to serve their clients out the door, and the emergency law allows that. We are so grateful that you are having a hearing on this issue, because now you can have a full discussion about what that really needs to look like. We support extending the ability of the restaurants to sell out the door to the extent that that license does not start to look like the license of an off-premise liquor store. Some of you are aware that the courts have a tendency to put their opinions in and to replace the role of state legislatures in liquor law. That only occurs when our laws start to become haphazard and do not continue to have a base in public safety and public health. So what we are encouraging is, in moving forward to add this new privilege for the restaurants, we hope that you would be very careful in considering how these laws reflect reasonable public health and safety measures. I have some information on page 2 of my testimony about how the courts have gotten involved in taking the role of legislatures in liquor law. Our association supports expediting a solution for the restaurants with this quickly approaching deadline of March 31st. However, we would like to carefully consider how this new world of takeout alcohol should operate. We have been sharing our ideas with Mr. Schneider and the Restaurant and Hospitality Association. Those ideas are on page 2. We suggested that carryout and drive-through alcohol should end at 11 p.m., that only beer and wine should be sold by the bottle and unopened. Please remember that they do not currently have a statutory authority to sell unopened containers of alcohol. Carry-out and drive-through alcohol sales should be limited to products and sizes that are already allowed under their license as liquor by the drink. and carry-out and drive-through alcohol should be sold in a sealed container such that it is obvious if the container had been opened after leaving the licensed premises. Our recommendation also included sales out the door having a food component. I would note that some of the emergency laws in other states have included this food requirement. Arizona's actual, not emergency laws, but their current statutes require to-go alcohol to be no more than 30% of a to-go order. Delaware's emergency order limits alcohol to no more than 40% of a to-go or drive-through order. And according to an article in the St. Louis paper, Missouri's emergency law had some specific requirements in it, saying that the cocktails must be in a durable, leak-proof, and sealable container, meeting minimum size requirements in the state regulations. And then the customer must purchase the beverage at the same time as a food purchase. These are just our recommendations. At this point, the amendment that was put on in the House does include some of the recommendations. We would prefer that you would adopt language that Jason has and that the director of ABC provided to sort of clean up that amendment. That amendment does not include the food requirement that we have requested, but it does cover many of our other requests. With that, Mr. Chairman, I would be happy to stand for questions.
Are there any questions for Amy? Yes, Senator Falscadeau.
Thank you, Mr. Chairman. Thank you, Amy. So it sounds like you're saying, and correct me if I'm wrong, that you want to clear up and make the distinction of if you are purchasing alcohol from a bona fide retail liquor store as opposed to a restaurant, with your adding in the food piece.
That is why we made that request. I want to say that we've been very pleased with the cooperation that we've gotten and the amendments that so far are on the table. So I don't want to make it sound like it's an all or nothing situation. Our concern is that if you start to make restaurants look like liquor stores, then at what point does a corporate entity who can have a chain of corporate restaurants come in and say, well, then I want to also be a liquor store because you're letting us do the same things. So that's where our concern lies. And I also want to point out that as you can see by the underlying bill, liquor stores sell, if they have a federal wholesale permit, to the restaurants. So their success is our success. So this isn't a competition thing. It's just making sure that these licenses are differentiated.
Are there any other questions? Yes, Senator Ware.
Thank you, Mr. Chair. So I know I can think of at least two places in Wichita that are breweries, and they're in a small enough setting that they're using all their backspace to make the beer. And for folks who also want to eat, they have a food truck pull up front. So so is there room for that business model in this?
Microbreweries are already allowed to sell their product out the door.
Any other questions? I do have one, and I'm looking at your testimony here, written testimony, and on your second one down there, there's your bullet point. It said only beer and wine may be sold by the bottle, and suggests these are no more than 50% of the sale. What would be the other 50% of the sale?
Food.
Okay, and my understanding, and correct me if I'm wrong, that decision, whether or not it has to be food, isn't that a county by county?
No. This would be different than the license requirement, which is based on their annual sales. The out the door requirement is simply the matter of that single receipt. So on the receipt, the alcohol would just be a portion of that purchase. Now, I want to be clear. We have no language in front of you that does that. The amendment recommended by the ABC was designed to expedite things. I would like, our organization would like to see the food requirement. The restaurants are not wanting to go down that road. For us, it just simply sets up that situation where we don't have someone showing up to buy bottled alcohol to go out the door.
Any other questions? Yes, Senator Longbottom.
Thanks, Mr. Chairman. Amy, thanks for your testimony. So if I understand your wishes here, if I order a $10 to-go pizza, then I would be limited to spending less than $5 on my bottle of wine?
Actually, our association would be fine with any level of a food requirement that the legislature wanted to put in the statute, even if it was just that there be food on the ticket.
Well, that's considerably different than 50%.
That's correct. The 50% was, I mentioned in my testimony, these were the ideas that we had put forth to the Restaurant and Hospitality Association. In the long run, our concern is just that it be clear that these are drinking establishments and not liquor stores.
Thank you.
Senator Dietrich.
Thank you, Chairman Alley. You actually triggered a thought when you asked about counties. The food piece, I mean, all of our counties are different, you know, whether you have restaurants or liquor stores or you have establishments who can sell alcoholic beverages. I was kind of thinking that this belonged at the county level, you know, because rather than putting it in statute, the food piece. So that was kind of my thinking. And then you had mentioned it. And I just think that might be a more flexible way for our counties to be able to participate in this if they want to or not, rather than putting it in statute. That was just my thought. I understand what you're saying completely. I was just thinking that might be a local control issue, that's all. I sound like I'm rambling. I apologize.
Thank you. Yes, Senator Falscadone.
Oh, thank you, Mr. Chairman. Okay, Amy, so just to clarify, so your concern or the food and sales, but what was the other piece that you
The other that we were asking for, so the House amendment has some unusual language in it that indicates first that the licensee can sell what they are licensed to sell under the club and drinking establishment. And then it says basically what goes out the door doesn't have to match up with what they are licensed to sell under the, as far as sizes. And so the ABC language that was provided would clear that up and just make it clear that drink sizes, drink products are the items that they are currently allowed to sell with their license. And we think that cleans it up nicely.
Any further questions or comments? Seeing none, thank you very much.
Thank you, Mr. Chairman.
And we will move back on our agenda for Mr. Jason Watkins. Kansas Beer Wholesalers Association. Welcome.
Thank you, Mr. Chairman. Jason Watkins, KBWA. And I apologize. One of my other clients is sponsoring the South Central Delegation Lunch, and nobody could be there to meet Hog Wild, and so I had to, and then they had me move the Hog Wild to Representative Hobbenson's office. That's why I'm sweating. So I apologize for so I apologize. And I will be very, very brief. I testified before your committee a couple of weeks ago on exactly this bill, but in a different number. Again, from the KBWA standpoint, this is kind of common sense approach that promotes healthy choices, as healthy as you can be when you choose to imbibe in alcoholic beverages. But it does allow more establishments to sell lower alcohol, lower calorie content products, which we think is a good thing. So I will leave it at that and answer any questions if there are any, Mr. Chairman.
Thank you. Is there any questions for Jason? Seeing none, thank you very much. Next proponent, Mr. Scott Snyder of the Kansas Restaurant and Hospitality Association.
Thank you, Mr. Chair and members of the committee. Scott Schneider with the Restaurant and Hospitality Association. We do support the underlying bill. We think the underlying bill makes common sense and is a clarification that's needed. We did work with representatives to add the amendment on the House floor, and we think it is a step. It's not an end product. We think we've worked with Amy, the director, and Jason Long over the weekend on some clarification language that we think would help quite a bit to make sure what we are trying to do is actually done and is actually enforceable. I think what we've got now is a problem out there where COVID has changed customers' behaviors. Not everybody wants to go into a store anymore, a restaurant. They want food. Nobody's really getting skinnier, I can attest to that. But we still want the things we like. And carryout has actually been a lifeblood for many of our dine-in restaurants that were acutely impacted, didn't have a drive-through, and this one provision was something the state could do that put $1 in somebody's pocket. I've said that now, I think, 8 different times in different bills. So this is, I want to make sure we understand, desperately needed. The March 31st date is a problem because people have bought a lot of product in order to make this happen. The opened versus unopened piece is a serious policy debate, and I think we need to understand what that means. If you were to order a hamburger right now, the way the law currently is written, the restaurant would have to open that beer, pour it into something else, and serve it. So you've got a time problem with beer. If you like flat beer, you're probably fine with it. If you want to get that product home in a condition that you like consuming it, then I'd encourage you to make sure that we could do an opened or closed provision for beer and wine. The mixed drinks is a different animal, we think. That's more complicated, and it does have a policy consideration that I think that we worked over on the House. We said, you know, you're probably right. Currently, the mixed drink size is in statute, and it's worked well for several restaurants. It hasn't, some restaurants just don't do it. But making sure that those size limitations in a mixed drink that are currently in statute are reflected in this bill, I think is very important also. So we don't want to sell bottles of tequila out our door, but wine is sold in smaller containers, and we kind of need to be able to sell them instead of having to incur additional cost. We need to be able to just sell the original unopened container of wine and beer, so we don't have to add more cost to what we're already doing. So there are two things. The closing at 11, I think, makes sense. Not being able to order carry-out alcohol at 11 kind of creates a common hour restriction with other sellers of that product, whether it's the microbrews or retail liquor. The piece that I will have a concern with is the food requirement, even if it's a minimum food requirement. Because again, we're looking at this, everything you require of us adds cost, and that's just another $1 that we don't get to make. We've got to pass that along, and it's going to discourage more sales. I do appreciate Senator Dietrich bringing up the local option piece. My thought on this is Johnson County in this last election just voted to do away with their county-wide 30% minimum that the Constitution allows each county to adopt or not adopt. And I think that provision in and of itself, even though it's a gross provision, it's not a per sale provision, is a meaningful way that the Constitution allows our counties to engage that concept. I don't know what the other states have as far as county food minimums, and I don't know what their constitutions require, but I do know that if a county tomorrow wanted to adopt a 30% food minimum, they could put it in front of the voters, and the voters could support it. So I think that's a meaningful alternative to putting something that was just overturned in Johnson County back into a statute. So I would oppose going down that road. But with that, I appreciate the timeliness. I know that we've been kind of pushing on this issue, trying to get it done. Tuck did mention that the bill goes into effect on publication. We'd probably ask you to change that to the register in order to try to get to the March 31st date, so there's not a gap that people aren't out there unknowingly breaking the law. So with that, I'd stand for questions.
Okay, any questions? Yes, Senator Faustico.
Thank you, Mr. Chairman Scott. So understanding both sides of this issue a little bit, so just plain devil's advocate. So, so the restaurant you know, if I'm going to a restaurant, I'm going there first to eat food. So what's going to make the major, without kind of compromising on this food piece, what's going to make the major distinction of restaurant, liquor store? So it's almost now, with what you're saying, in an opposition, that now the restaurant is a one-stop shop for me. I can just buy, you know, so just to be level and you know, balanced on this issue, what would be a compromise piece, and what's that distinction? That I need that distinction.
So the type of sale, I would say, is the distinction. You know, you do think of restaurants and how to get product from a restaurant as something that's either easy, it's hard. You think the same way, is the liquor store close to me, is it farther away? We're not talking about delivery here, which I want to have that conversation, but the bill that I wanted to have that conversation isn't ready yet. But the other distinction is drinking establishments are taxed at another 10%. So if you want to purchase your alcohol from a drinking establishment, you're going to pay another full 10% just to get the bottle of beer or the bottle of wine. So there are bright distinctions, and that alone should incentivize people. If you want an unopened container and no food, probably just go to your liquor store to get it. We're not trying to compete with them. In fact, Amy, pointed out, we're their customers. We have to buy our wine and spirits from the federally wholesale licensed liquor stores. So we're kind of in this together. So we're not trying to be liquor stores. We're not asking you to waive the 10% drink tax. That's not what we want to do.
Any other questions? Seeing none, thank you very much. We do have neutral, and that is Director Debbie Beavers again. Debbie?
Good morning, Mr. Chairman, members of the committee. My name's Debbie Beavers, ABC Director. Thank you for the opportunity to testify. We are neutral on this bill. In the interest of being brief, the underlying bill, the original bill, does add cereal malt beverage throughout the Liquor Control Act and Club and Drinking Establishment Act. I would point out that current law does allow on-premise licenses to also get a CMB retailer's license to sell those popular low alcohol content, low calorie malt products. This bill would eliminate that requirement for them, so they would not have to get an additional license for those who want to do that. The bill amended the language on page 23, lines 17 through 24 is confusing, and it does reference mixed drinks, which there is no definition of mixed drinks. So the bill before you has no definition of that. So could a mixed drink be vodka poured into a cup, sealed in a bag to go? I don't know without a definition the way it's written right now. ABC does support the concept of not opening those bottles of wine and beer prior to bagging them to go in the interest of public health and safety and product integrity. We're also flexible on sealing unopened bottles of beer or wine in a tamper-proof bag. But we do have concerns when the laws begin to blur the lines between certain license types. On-premise, off-premise consumption. Offering to-go option has been a lifeline that's been necessary for these on-premise licensees during the pandemic, but do there need to be any limitations applied? I don't know. That's a question for you to debate. I can tell you that the ABC is aware of an instance where one person ordered 30 margaritas to go from an establishment to take to a party. Is that the intent? Should there be some bumpers on this? I don't know. I'm asking the question because as written, nothing would occur that from happening. So having said all that, I do believe in working with the industry. We have offered some simplified language to address that confusing language and make it a little bit more clearer. So with that, Mr. Chairman, I'll be happy to answer any questions that you have.
Questions for the director? Yes, Senator Falscadeau.
Thank you, Mr. Chairman. So Debbie, just a question for you. So when you, the last statement you just made, so Spangles, so you can buy a little margarita to go. I mean, so would that apply here? I mean, can you buy, I don't know, can you buy as many as you want there at Spangles in the drive-through?
Yes.
Answer was yes. Is that correct?
That's correct.
Thank you. Is there any other questions for the director? Seeing none, thank you very much for being here today. Are there any other neutral? Are there any opposed? Seeing none, we'll close the hearing on House Bill 2137. We could open the hearing on House Bill 2252 if we will make our comments quickly and try to get out of here on a reasonable time. So we'll open up House Bill, close it on 2137 and open up House Bill 2252. And Jason, can you give us a briefing on that?
Yes, Mr. Chairman, members of the committee, this will be very brief because you have seen this bill already in Senate Bill 252. So I'll just highlight the changes that the House did to the basic underlying bill. This is the bill that would create a fulfillment house license so that those warehouses and entities that assist special order shipping licensees in shipping wine into the state directly to the consumer would have to obtain a license from the director in order to do so. The House made changes so that each fulfillment house license would be required for each location that is involved in shipping wine to Kansas residents. That would be a $50 biennial fee for each license at each location. Other than that, the same requirements in terms of packaging, labeling, reporting are all the same for the fulfillment house licensee as you heard in Senate Bill 252. And the bill also adds the definition of fulfillment house to 41-102 to clarify that. The bill will go into effect on July 1st of this year, and I'd be happy to answer any questions.
Are there any questions for Jason? Seeing none, thank you, Jason. Our first proponent, Mr. Chuck Duncan, General Counsel for the Kansas Wine and Spirits Association.
Thank you, Mr. Chairman. I will be brief. You heard my testimony a couple weeks ago. I demonstrated all this paperwork. I talked about 198,000 shipments into the state, how there were 60% of those shipments came from fulfillment houses, and the ABC had no way of knowing how to track them with the hopefully soon to be quarterly reports that you're going to get, et cetera, from the wine shippers. This House bill has the amendments in it that I proposed the committee add to the Senate bill. These are amendments that are agreed to by the agency, the Wine Institute, and ourselves. So at such point as time you do a markup, we'd ask that you incorporate the House version of the fulfillment license and go from there. And with that, I'm going to go to Spangles and get myself a margarita grande to eat at consume at lunch. Thank you.
Okay. Thank you. Any questions for Mr. Duncan? Seeing none, next proponent is Larry Ann Brown from the Wine Institute.
Thank you, Mr. Chairman, members of the committee. As I was a few minutes ago, I'm Larry Ann Brown here today on behalf of the Wine Institute. As Tuck mentioned, there is support for this bill as it's written. I do believe that there are amendments that were included in this bill that the Wine Institute does support. And with that, I would also be happy to stand for questions.
Are there any questions? Seeing none, thank you very much. And the last one, last proponent that we have is Amy Campbell, again, Kansas Association of Beverage Retailers.
Thank you, Mr. Chairman. Amy Campbell, Kansas Association of Beverage Retailers. We support this bill with the House amendments. Thank you.
Thank you very much. Any questions? All in favor? No. we do have any other proponents? We do have a neutral, Director Debbie Beavers. Director?
Thank you, Mr. Chairman. Debbie Beavers, ABC Director. I too will be brief. While we did not bring this bill, it is very important for us at the agency to be able to compare fulfillment house reports with special order shipper reports, with common carrier reports to identify those unlawful shipments. And I'll be happy to stand for questions.
Thank you very much. Are there any questions? Seeing none? Yes. Yes.
The House bill creates literally no fiscal note. The fiscal note that you got on the original bill was like $40,000 or something because the ABC had to redo all of its programming. This fiscal note is de minimis. And in fact, I think you said with these amendments, there may not be any fiscal note. So that's another reason to move forward on the 2252 version of this bill because it eliminates costs to the agency.
Okay. Thank you. Any questions? Thank you very much. Are there any other neutral? Any opponents? Seeing none, we'll close the hearing on House Bill 2252. And committee, next meeting, which is tomorrow, we should have a new member, and he will be sworn in this afternoon. So we will welcome Senator Reichman for be here this afternoon. So thank you very much, and this meeting is adjourned.